The first area we're going to talk about with regard to making arguments to help underwriters lower premium by trying to convince the underwriter that in fact past losses couldn't recur in the future or they couldn't recur in the same way with the same loss values is individual claim arguments. And you can download a checklist of all of these arguments on the Insurance Dragon website to help you. So the first issue that we're going to talk about is a big one for most clients, which is fraud. Unfortunately, when I talk to clients for the first time, they typically find one or two or three claims that are legitimately fraudulent that they really are upset about. But unfortunately, underwriters look at fraud as part of the system. It is just part of the system because the workers' compensation system in California bends over backwards to such a degree to aid the injured worker that a lot of times fraudulent claims get through as well. But there are arguments that you can make in this regard, but they have to be pretty concrete. So we'll go through that right now. The frustration that clients feel often has to do with the fact that they ask the insurance company to perform sub rosa, which is investigation into the claimant, largely video investigation, following the claimant to try to prove that they're actually capable of working when they say that they're not. And a lot of times insurance companies resist performing sub rosa, and it's simply because fraud is so hard to prove in the workers' compensation system. But one area where you can be effective is if the claimant makes a false statement. There's a specific insurance code regarding false statements that witnesses make. And so the typical scenario is that someone has work restrictions that say they shouldn't lift anything more than 5 pounds. And they're off work, and they're videotaped actually lifting something that's much heavier, perhaps a 5-year-old child, and they're carrying them around all day, and the video evidence is very compelling, very convincing. But what often happens is that claimant gets into court, and with the video evidence confronting the claimant simply says to the judge, gee, I had a bad experience that was really stupid. The next day I really had horrible pain and it was much worse, and that was a big mistake. That was one day when I tried to do something I couldn't. And too often, unfortunately, that is an effective argument for the claimant. However, if the claimant has made a false statement, then a lot of times the insurance company will pursue the fraudulent claim to the finish line. And a false statement might be saying to the doctor, I am not capable of lifting more than 5 pounds at any one time. And now a lot of times the insurance companies will pursue that. So fraud is a frustrating area. If you work with your broker can guide you in terms of which arguments will be valid and which ones won't. The next area is subrogation. Big area where insurance companies fall down a lot, unfortunately. So it's an area where it is truly ripe for argument if an insurance company has not followed up on a third party that caused an accident. So for example, if one of your workers was rear-ended by somebody else and the insurance company paid the workers' compensation claim for your injured worker and didn't pursue the subrogation when the other party was identified, the other party had insurance, and it was a legitimate opportunity, then it's a very valid argument to make that claim value should be reduced, if not offset completely, in the mind of the underwriter because of the failure of the insurance company to pursue subrogation. Unfortunately, very common that insurance companies fall down in this area. Indemnification is somewhat similar, and this is where you have a contract with someone for your workers to perform a particular service on their premises or for their business. And in agreement for you performing that work, they've agreed to indemnify you for any injuries. Very valid reason that the claim should reflect that at some point the claim value should be reduced based on the amount of recovery from the third party for that injury. And so there may be a lag time here where the loss runs show a very high value, perhaps a claim of $54,000, for example, and you know indemnification is coming, it just hasn't arrived yet, and the insurance company hasn't recognized it in the loss runs. Very valid argument to make is that indemnification will offset that claim in part or perhaps totally. And the last argument right now we're going to talk on this segment is arising out of employment and in the course of employment. Those are technical terms in the insurance code. For workers' compensation claims to be compensable, to be payable, the injury has to arise out of the employment and in the course of the employment. And what that basically means is the employee has to be doing something that is typical to what their requirements are on the job and when they're injured in order for the claim to be paid. And so, for example, if someone is sent on an errand and while they're driving to perform that errand, they stop off at their aunt's house, and at their aunt's house they trip, fall, and break their ankle, that would not be a compensable claim because it did not arise out of the employment and during the course of employment. Pretty common sense argument, but a lot of times those claims are paid, and you can make the argument, and the underwriter usually will accept that argument, that that claim value should not be considered going forward in determining future premium.